Whenever the state misuses power, Constitution gives remedy through writ jurisdiction. There are two major provisions. Article 32 gives right to directly approach Supreme Court for enforcement of fundamental rights. Dr. B.R. Ambedkar called it the heart and soul of the Constitution. Article 226 gives power to high courts to issue writs not only for fundamental rights, but also for other legal rights. Remember the difference. Article 32 means Supreme Court. Article 226 means High Court. Article 32 only for fundamental rights. Article 226 has wider scope. UPSC asks this often. Which one is wider? Answer is Article 226. Indian Judiciary can issue 5 writs. These were adopted from the British legal system. They are Habeas Corpus, Mandamus, Prohibition, Certiorari, Quo Warranto. These are judicial commands. Memory trick. Body means Habeas Corpus. Command means Mandamus. Stop lower court means Prohibition. Correct wrong order means Certiorari. By what authority means Quo Warranto. These 5 writs are core constitutional remedies. Habeas corpus means produce the body. If any person is illegally detained, court orders authority to bring that person before the court. Authority must justify the detention. It can be used against police. It can be used against state authority. It can also be used against private person in illegal confinement. It cannot be used when detention is lawful. It cannot be used when person is held under valid court order. This writ protects personal liberty under Article 21. It is strongest weapon against illegal arrest. Mandamus means we command. Court orders a public authority to perform duty which it is legally bound to do. It can be issued against government departments. It can be issued against municipal bodies. It can be issued against public officials. It can be issued against tribunals. It cannot be issued against President of India. It cannot be issued against governor. It cannot be issued against private body without public duty. Example, if authority refuses license despite legal duty, mandamus can be issued. This is a favorite UPSC confusion area. Prohibition is issued by higher court to lower court or tribunal while case is still pending. It means stop proceedings because lower body exceeded jurisdiction. It is preventive writ. Certiorari is issued after order has already been passed. Higher court quashes order due to lack of jurisdiction or legal error. It is corrective writ. Memory trick. Prohibition means prevent before damage. Certiorari means correct after damage. Quo warranto means by what authority. Court asks a person holding public office to show legal authority. It is used when someone illegally occupies public office. Conditions are: office must be public, office must be created by constitution or law, office must be permanent, person lacks qualification. It cannot be used for private office. Important point: any citizen can file it. Locus standi means right to approach court. Normally, petitioner must be affected person. Strict standing usually applies in mandamus, prohibition, certiorari. Relaxed standing usually applies in habeas corpus, quo warranto, meaning any person can approach court in such cases. This reflects public interest logic. If person is illegally detained, use habeas corpus. If authority is ignoring legal duty, use mandamus. If lower court is hearing case without jurisdiction, use prohibition. If lower court already gave wrong order, use certiorari. If unqualified person holds public office, use quo warranto. For prelims, identify situation and match correct writ. Supreme Court, under Article 32, has nationwide jurisdiction for fundamental rights. High courts, under Article 226, work within territorial jurisdiction. High courts are often first practical remedy because they are easier to access and have wider scope. Supreme Court is guarantor of fundamental rights. High courts are broader constitutional protectors. Many students think Article 32 is always better than Article 226. This is wrong. High Court under Article 226 has wider power because it covers fundamental rights plus other legal rights. Supreme Court under Article 32 is only for fundamental rights. But Article 32 itself is a fundamental right. So remember, in scope, Article 226 is wider. In status, Supreme Court is apex court. ADM Jabalpur versus Shivkant Shukla. During emergency, issue of liberty and habeas corpus came before court. Later, this judgment was strongly criticized. L. Chandrakumar versus Union of India. Court held that judicial review by high courts and Supreme Court is part of basic structure, meaning judicial review cannot be removed. So, final takeaway is, writs are backbone of constitutional governance. Thank you.